The motion is predicated on the fact that both sobriety tests, including the horizontal gaze and nystagmus test, were not conducted, and that the PBT results, because the PBT device was not properly calibrated, did not factor into the probable cause DUI arrest. Now, what I try to make clear in my opposition to the motion is that probable cause is not a preponderance of the evidence. The case law is very clear that probable cause is less than a preponderance of the evidence. The way the United States Supreme Court has described probable cause, as the court is well aware, is a fair probability that criminal activity is afoot. In this case, the criminal activity is driving under the influence. Testimony of the officers, I think, is important, and I think Lieutenant Ames' testimony is most relevant. Lieutenant Ames saw Mr. Bruns pull in, saw him driving the white Chevy truck, saw him park and exit his vehicle. Now, there were certain things that Lieutenant Ames did not do perfectly, and he admitted he did not do a perfect job. The Fourth Amendment does not require perfection. It only requires reasonableness, and the Supreme Court of the United States has made that clear time and again, most recently in the Hine v. North Carolina case, which is cited in the opposition. What did Lieutenant Ames do well? He noted very clearly in his police report 4 signs, objective signs of impairment. Mr. Bruns had a strong odor of alcohol. Not just a mild one, not a moderate one, a strong odor of alcohol. That's the first. Number 2, Mr. Bruns had red, watery eyes. Number 3, he had a red, flushed face. In fact, Lieutenant Ames said that his face was glowing the way that you would expect from someone under the influence of alcohol or another substance. And number 4, Lieutenant Ames noted in his report that Mr. Bruns was unsteady on his feet. He didn't detail or elaborate in his report what that meant, but on the stand he said that he was actually having even to lean up a little bit on Lieutenant Ames' patrol vehicle to steady himself. These are 4 objective signs of impairment that the state submits is more than sufficient to affect a DUI arrest based on probable cause, which is not a terribly demanding standard. Now, the Nevada Supreme Court in the McLeod case, which is cited in the opposition, held implicitly that a DUI arrest, or not a DUI arrest, but rather evidentiary testing would be acceptable based on only 2 objective signs of impairment. In that case, Your Honor, and I have the case in front of me, the signs of impairment were odor, and there was nothing about the strength or distinctiveness of the odor. It was just noted that the woman involved, Miss McLeod, had an odor of alcohol, and that her eyes were bloodshot. So the odor in the eyes alone, the Nevada Supreme Court said in 1990, was sufficient probable cause to subject her to evidentiary testing. The reply to the opposition makes the point. There's a difference between subjecting someone to evidentiary testing and arresting. I would argue, Your Honor, that in most cases, those are coterminous analyses. So the analysis you would conduct as to whether you have probable cause for an arrest for DUI is the same analysis or a similar analysis to the analysis as to whether to submit someone to evidentiary testing. To the extent there is a difference, Your Honor, submitting someone to evidentiary testing, especially blood testing, which was the testing involved in McLeod, it says very clearly in McLeod it was a blood test. To the extent there's any difference between the probable cause needed for a DUI arrest and the probable cause needed for a DUI evidentiary test, the DUI evidentiary test is actually a higher standard. And you don't have to take my word for it. You can look to what the United States Supreme Court said all the way back in 1966 in the Schmerber case, which was later overturned by McNeely, and I will mention McNeely next, but it wasn't overturned on this basis. In Schmerber, the U.S. Supreme Court said that the mere fact of a lawful arrest does not end our inquiry as to whether a blood test, that is a needle entering the skin and taking blood forcibly from a person, satisfies the Fourth Amendment. In fact, the U.S. Supreme Court said that that was very intrusive, and so the standard would be quite high, that the arrest itself wouldn't be sufficient. It said a clear indication that such evidence will be found as to the DUI is necessary. Now remember, this is still in the context of probable cause, so it's still less than preponderance of the evidence. It's just a fair probability. But to the extent there's a difference between what you need probable cause for an arrest versus evidentiary test, I think they're coterminous, but the evidentiary test might actually be a little bit higher. So that's the first point I want to make. And the U.S. Supreme Court in McNeely actually repeated itself in that respect and said that principle applies to the type of search issue in this case, which was a blood test, which involved a compelled physical intrusion beneath McNeely's skin and into his veins to obtain a sample of his blood for use as evidence in a criminal investigation. Such an invasion of bodily integrity implicates an individual's most personal and deeply rooted expectations of privacy under the Fourth Amendment. We're still talking probable cause, but I think to the extent we don't know in McLeod whether there was an arrest, and I researched McLeod, Your Honor, and unfortunately I wasn't able to pull any of the briefs because it's out of our Westlaw plan, but it suggests that maybe there was an arrest. You need an arrest before you can effect an evidentiary test. But to the extent it's not clear because Ms. McLeod was actually at the hospital and the officer just basically said, you're already at the hospital, we're gonna have you do a blood test. It's not clear whether there was an arrest. I'm basically arguing that that's irrelevant for the purposes here. Now, the analysis doesn't stop there because you don't just have 4 objective signs of impairment. In this case, you actually have 6. I think that Lieutenant Ames presented very credibly, and he testified that although he did not note these facts in his report, there were 2 additional objective signs of impairment that he noted. The first was that when Mr. Bruns stepped out of his vehicle, he walked to Lieutenant Ames with an unsteady gait. That the walk was something that Lieutenant Ames would believe would be something that would suggest some level of impairment, especially when you add it on top of the 4 other factors that he noted in his report. The second additional factor is that he said that Mr. Bruns actually admitted to drinking alcohol. It wasn't a huge amount, but the admission of drinking before driving is another factor. Now, the final question that I asked, well, the second to last question, I guess, that I asked Lieutenant Ames was whether he took in the totality of the circumstances. And I also previously asked Lieutenant Ames, would he have effected the DUI arrest without the benefit of the PBT and without the benefit of field sobriety tests? He said yes. In fact, my very last question to Lieutenant Ames was, do you sometimes make arrests that you think are based on probable cause without the benefit of field sobriety tests? He said yes. So in this case, we have more than McLeod, where you only had 2 objective signs of impairment, odor and eyes. In this case, we have 4. We have odor, eyes, face, and unsteadiness. And we actually have 2 additional ones, an unsteady gait and also the admission of alcohol consumption. The final thing I want to point out for the court is that the case law is actually well established and on the side of the state. I'm quoting here from a case by the United States Court of Appeals for the Fourth Circuit. It's United States v. Walker. The jump site is 607 F Appendix 247. The court says that, it quotes, other circuits, albeit in unpublished opinions, have found that there existed probable cause to arrest in cases where police had not conducted field sobriety tests prior to arrest. They cite a case from the Third Circuit in 2005 that said it found probable cause for the DUI arrest where the officer observed staggered gait, bloodshot eyes, and alcohol on his breath, and the admission of drinking to alcohol. I would argue that actually that case is very similar, almost on all fours with our case. Another case they cite is from the Second Circuit, and they also cite a practice guide that refers to the fact that you don't need field sobriety tests to find probable cause for a DUI arrest. So I think given the totality of the circumstances in this case, and remember, it's inappropriate to have a divide and conquer analysis where you focus just on one fact and say, well, that alone it doesn't necessarily imply impairment. It's a totality of the circumstances analysis where you look at all 4, or in this case 6 factors that suggest that there's impairment. And I think at that point there was a fair probability, which is probable cause, to arrest Mr. Bruns for DUI, and I think that the suppression motion should be denied. Thank you.
All right, thank you.
Your Honor,
Mr. Schaerer, go
the
ahead.
Fourth Amendment does not require perfection, only reasonableness. The United States Supreme Court said so in Hine, and this is well-established case law. And this is especially true in a case like this where you don't just have a DUI investigation. In fact, the primary investigation is a battery investigation. The DUI investigation, to the extent it's not perfect, is understandable under the circumstances because it was on top of a battery, a very serious battery investigation where both officers testified they believed that the victim might die. So they had a lot on their minds, but they still conducted a probable cause-worthy investigation. And the defense takes a very blunt view to the State v. McLeod case. Yes, it is a civil, quasi-criminal case, but that doesn't change the analysis of whether there was probable cause to put a needle, for the government, to put a needle under the skin and draw blood, which is the primary concern of McNeely, Schmerber, and other cases, including McLeod. Now, one of the statements the defense made was that in McLeod, there was no discussion of probable cause. That is disingenuous. There was a discussion of probable cause. I'm looking at McLeod right here, and this is quoted in the opposition brief, Your Honor. It says, "We note, however, that Officer Hagen also testified that he noticed that McLeod had an odor of alcohol on her breath and that her eyes were bloodshot. These indications of intoxication were adequate grounds for Officer Hagen to have required McLeod to submit to an evidentiary test. Although the term probable cause does not appear, there's nothing talismanic about the term probable cause. The discussion of adequate grounds is within the Fourth Amendment context. The government has no right to take blood from a person unless the government has probable cause." Now, you can also look to the motion itself, where you can see from the defense, they cite the statute in Nevada that says you need a probable cause for an arrest. That statute doesn't say probable cause, it says reasonable grounds. But all the courts know that that's interpreted as probable cause. So it says on page 5 of the motion, pursuant to NRS 484C.1503, the results of the preliminary test must not be used in any criminal action except to show there were reasonable grounds to make an arrest. The very next sentence from the defense brief is, "The burden rests with the prosecution to establish probable cause for an arrest." The clear implication is that you read reasonable grounds in the statute as probable cause, and you read in McLeod adequate grounds as probable cause, because this is a Fourth Amendment analysis. And I think it's very important that even though McLeod is a civil quasi-criminal case, it doesn't change the probable cause analysis, which is the same. And in that case, in McLeod, the Nevada Supreme Court said 2 objective signs of impairment was sufficient for a probable cause evidentiary test. There would be no reason in law, logic, or fact to do anything different with the 4 objective, in fact, the 6 objective signs of impairment in this case. The final thing I want to point out is that the federal cases that I've cited to you before already corroborate and buttress the argument I'm making. So you don't have to take my word for it. You don't have to take my word on my interpretation of McLeod. I think that analysis is sound. But the federal courts have already followed suit in this respect. It wasn't just the Fourth Circuit, it was also the Third Circuit, the Eastern District of New York, which was affirmed by the Second Circuit, a practice guide. The 10th Circuit has also done the same thing. And I would note that the 7th Circuit, in a case that I just did some quick research on, said probable cause is something less than preponderance of the evidence. So we know we're not dealing with more likely than not here, Your Honor. It does require a fair probability. But I submit to the court that as the Nevada Supreme Court recognized in McLeod, 2 objective factors rise that level of a fair probability that Mr. Bruns was under the influence of alcohol and driving. And I would submit that a fortiori, 4 or 6 factors is more than sufficient. Final thing I want to point out, and I cite this in the opposition brief. Lieutenant Ames is not your garden variety deputy. He has incredible experience. He is a DRE expert. He's a field sobriety expert as well, and he's an instructor. He instructs in those areas. And so he has a level of experience that is well above the already high level experience that officers in the field have. And the U.S. Supreme Court said very clearly that in the totality of the circumstances analysis, although it is an objective test, and you don't take the subjective belief necessarily as dispositive of the officer, that the U.S. Supreme Court has recognized that in forming probable cause for an arrest, police officers may draw on their own experience and specialized training to reach conclusions that, quote, might well elude an untrained person. So I think that that is highly relevant here. And the state is not mixing apples and oranges. The state is looking at the Fourth Amendment, looking at the probable cause analysis, and giving you a clear roadmap to deny the motion. Thank you.
All right.